Greetings and salutations. Welcome to another episode of the Legal Beagle. This is a Kurt update, and the phrase of the day is "keep the faith." That was the message I got from Kurt yesterday, and so we are continuing to battle the Ninth Circuit, the Western District of Seattle, and the superior courts in Washington State. They have not issued the writ of mandamus. They have not done anything. They have not recused themselves. They have just sat on it. There's precedent for having to do something with a writ of habeas corpus um, within a certain time frame, which is now expired. So I'm not going to keep you too long because I'm going to put all the hearings behind this. There's 5 hearings I'm posting right now. One is on July 31st, a municipal hearing. It's only 6 minutes long. Kurt wasn't there. On August 2nd, there's a municipal hearing. It's 12 minutes long. Second one. And then there was another municipal court hearing on August 5th, which is an hour and 11 minutes long. And Kurt is in there speaking. I think he's in the second one too. Then on August 5th, the same day, the Superior Court judge, it's 1 minute long. I don't think Kurt's in there for that. And then on August 6th, there's another Superior Court hearing, which was 46 minutes that Kurt was in. What? It's a clown show, guys. It's really a clown show at this point. They don't know what to do with this man. They don't have jurisdiction. It's a threat. Jurisdiction, for those that don't know, is a threshold issue that nothing can proceed until the jurisdiction has been established. And they seem to just be dancing around this while he sits in jail. So I do have the number Kurt gave me of the administrator for the petition for habeas corpus in Judge Robart's court in federal court, and that number, the administrative number, is 206-370-8449. 206-370-8449. And if you are so inclined to call and ask them what's taking so long on this writ of habeas corpus that should have been handled weeks ago, that would be great, I suppose. We're continuing to try to communicate with the courts, and they just don't have any good answers for anything. But that's not surprising. And so, in an effort to not make this too long, just wanted to let you know, he says keep the faith. He's in good spirits. Still hasn't had access to commissary. No access to pen and paper. That may change after these hearings. I haven't spoken to him after all of these hearings, but hopefully he'll be getting his commissary so he can at least eat a decent meal and do something other than pay for his phone calls. Because right now, all he can do is pay for phone calls because he's in booking, because he hasn't signed conditions for release, and he doesn't want to give them any jurisdiction. Right, so signing papers will give them jurisdiction, even if it's under duress. So he's foregoing the temporary relief in the prison to try to force their hands here. And so I don't know what's going to happen, but I'm going to let y'all get into it, and I'll put the timestamps right as you see on the side right here. I'll put the timestamps of where all the court hearings start, so you can just skip to what you want to see. And it's something to see for folks. It's certainly a show for a banana republic. It's not the America we were taught about or grew up in. That's for sure. So without further ado, here are the hearings.
Please be seated. Good afternoon, everybody. All right, court's just here for one case, which is the bench youth matter.
Yes, Your Honor.
Hold on. Hold on, Your Honor. Counsel, let me go on the record.
Oh, that would be good.
Okay, I'm on the record now.
Okay. I can call City of Seattle versus Kurt Benchoof. He has several matters. 671-384, 669-329, 676-216, 676-175, 656-749, 675-405, 656-748, 676-463, 676-492, and 676-207. Afton Lewis appearing for the city on all of these matters.
All right, and he is self-represented in these matters. That's the court's understanding, and he has refused to come to court today.
Actually, Your Honor.
Mr. Roy, are you on one of these?
He's being represented by Reagan Roy in all these matters.
Yes,
Oh.
Your Honor. So, from what I can tell, procedurally, I was appointed to one case that Mr. Benshoof's matter was granted pro se on,
Mm-hmm.
and I was recently assigned several other cases. So, just so the court is aware, I'm trying to pull up now the cases that I've been assigned to.
Okay, and didn't you withdraw from a case?
I did withdraw from one case, but I've since been appointed to. I believe the case I was appointed on and withdrew was case 675-405.
Okay, and are you reappearing on that one or no?
So 05 is you withdrew, correct?
Yes.
Okay.
And it seems like on 7/29 there was a bench appointment.
Okay.
I'm assuming
That was me. I didn't appoint you. Because I heard this on the 7th, I think. Didn't I?
On 7/29.
Was that this week?
Yeah, that was this week.
Okay,
I was here. for
You,
that,
so I wasn't
Your
here for
Honor.
that. So somebody,
Yeah.
okay.
Yeah, he refused to come up on Monday, so we did send these matters over so that the DPD could be appointed to his matters.
Gotcha. All right. So, Mr. Roy, at this point, what are you appearing on? Which numbers?
so. From what I've been informed by my office is I've been appointed to case 676-463, 676-175, 676-216, 676-207, 676-492, 671-384, 669-329, and I would assume 675-405, which is the one I withdrew on that I have been reappointed.
So let's handle the cases you're assigned to first, and then we'll handle the rest of them. So he's refused. What would you like to do from your perspective?
Your Honor, I do not have 3-4 authorization to do anything with these cases.
Okay.
So I am unable to.
Proceed.
Yes.
So my clerks have issued a request set this for the DV review calendar at 10:30 a.m. on Friday. Are you available for that?
I am.
Okay. We'll go ahead and do that then. Is there any objection from the city?
No objection, Your Honor.
So for all the cases, we're going to set everything together then, because they're all going to be in a similar procedural posture. This will be set over until Friday, 10:03, 8:45 a.m. It will be excluded period for all of the cases. Obviously, Mr. Roy can't waive, and Mr. Benchoof can't waive because he's not here for the other cases. Was the 29th the day when the court management system was down?
Mm-hmm.
Okay, that's why there's no notes in there, and that's why I thought I was the last person to touch this case. But that's okay.
So this Friday, the 2nd, 8:45 and 10:03, and then the rest of the matters are tracking in there.
Yes. Mr. Roy, do you anticipate being appointed on the remainder of the cases at this point, or no? No, I didn't.
No.
Okay, all right. I'll set over to Friday. All right. This is the only matter. These are the only matters that I'm handling up here today. I don't think we need you for anything else, Mr. Roy, unless you get other cases on this calendar.
We have one more,
Okay,
but
is it ready?
It is ready.
Okay, I can do that too, and then I'll get out of here. But just give me a second. I gotta update notes for 10 cases, so just stand by. What judge did the bench appointment, just so I can update the notes on that?
I'm not able to see.
Oh, you mean on Monday?
Yeah, who appointed DVD from the bench?
Let me see who was there on Monday.
Because there's no notes at all in mine.
Hanula?
Okay,
Tim?
pro tem did, okay,
Mhm.
gotcha, that's makes more sense. Alright. And lower bench, let me know when you're ready for Mr. Roy's case, and then I'll step off.
21, 22, 23, 24, 25, 26, and 27 matters. Those are case numbers 676-175, 671-384, 669-329, 676-216, 656-749, 675-405, 656-748, 676-463, 676-492, and 676-207. These are the Kurt Bench matters.
Good morning, Your Honor.
Morning.
William Boyd with DD. Just so the record is clear on all of these cases, I'm appointed to case 676-463, 675-405, 676-216, 676-175, 671-384, 676-492, and 676-207. Previously, with regards to case 675-405, Mr. Benchoof was granted his pro se motion, so the portal indicates that there is a notice of withdrawal by myself. However, still appears that I am listed as attorney of record for that one, but I am the attorney of record for the other cases that I just said. For the court, I do not have the report authorization to do anything or address these cases.
Okay. Just as a preliminary matter, so Mr. Roy, if okay, so I know that, okay, so I'm looking at my screen here. So you've noted Mr. Bench was per se on 656-749, but would it make sense for the court to direct appoint you on, there, it looks like there are two cases where no counsel is, let's see, that would be 669-329 and 656-748. I don't see any counsel noted. Would it make sense to appoint you so that you have, or would you prefer not
I do
do?
not have his authority for that, Your Honor.
Okay, I understand. Okay, all right. So, okay, so the court understands that these are all pretrial cases, correct?
Yes, sir.
Is that right? Okay, and that Mr. Benchoof is in custody and he's refused court today. Mr. Roy, just another question too that perhaps you can or cannot answer. The court had some information that perhaps that competency was raised as an issue in another at King County Superior Court. Do you know anything about that?
Yes, Your Honor, that was raised sua sponte in King County Superior Court.
Okay.
And I believe that there has been a finding of returning of comp.
Oh, okay, thank you. That's helpful. Okay, so at this point then, City, what would you like to do with, what do you suggest we do with Mr. Benchoof's cases?
The city would just ask that the court have a short set over for these cases and exclude any time between now and the next court date.
Okay. Okay, now I wasn't able to go through each of these in detail. I think that makes sense to set these over and exclude time. Are these all on the same time for speedy trial calendar, or are they all different? I guess, Mr. Roy, do you know that offhand?
I do not, Your Honor.
Okay, okay.
September 3rd.
I'm sorry, Clerk?
So they'll have September 3rd as speedy expiration.
As expiration September 3rd? Okay, I'll have to, okay, so let's do this. Okay, so there's an issue here where I believe that the other judges have had to recuse themselves, some of the pro tems as well. I, at this point, can still hear Mr. Benshoof's cases, so I don't know if I have a choice except to set these. Let's see, Laura Bench, what is our Monday? Let me just see what our Monday pretrial calendar looks like, because this, yeah, I'll take a look too. Mr. Roy, did you have a preference on the new date?
Do not have a preference, Your Honor.
Okay, thank you.
We're looking at August 5th.
Yep.
Yeah, 26 out of 29 cases.
Okay. All right, so I'm going to, let's see, give me just one more moment, please. Okay, I'm wondering if it would make sense to set them in the afternoon instead. Mr. Roy and Mr. O'Brien, if I set these, because it's such a big number of cases, my pretrial calendar looks pretty full on Monday morning. Right now I've got 2 contested revocation hearings for the afternoon. Would that work for both of you if I did that instead of setting it in the morning?
That would work for the city, Your Honor.
Mr. Roy, would that work for you?
Works for defense.
Okay, all right, Laura Bench, let's do this. I'll do a special set all of Mr. Bench's pretrials for August 5th at 1:30, please. Okay, and then the court is going to exclude time. I'm going to need to look at these more closely and figure out exactly where that puts us. Okay, so Laura Bench, do you need some time to do this?
Yes, please.
Okay.
Madam Clerk is gonna help me, so I can move on.
Okay, very good, thank you. Okay, let's see, Mr. Roy, was there anything else, or Mr. O'Brien?
Only thing from me, Your Honor, just so the record's clear here,
Uh-huh,
the case the pro se motion was granted on was 675-405. But that's all I have.
okay. You know, Mr. Roy, I have Mr. Benchu pro se on 656-749. Is that not correct? And then I have you representing him on 675-405.
So when these cases were first back on warrant status, I was only assigned to one, and that was 675-405.
Mhm.
And when that first hearing happened, Mr. Vinshu's motion was granted, and I was withdrawn from the case.
Mhm.
And I believe that I was appointed to several other cases after that,
Mhm.
and that is why I am appointed to the other cases here.
Okay. This is very confusing here. Okay, I'm sorry, you might be talking in circles, but can you just, so from your perspective on 656-749, what do you believe he's pro se, or that you're representing him on that one?
I do not have noticed that I've been appointed to that.
Okay, all right, okay, so I think that he is. Okay. All right, but, okay, in any event, yes, the court is excluding time from all of the cases, whether or not Mr. Roy is representing Mr. Benchif on these, because he is not here today and there's no 3-4 authorization, so, okay. And as I was saying, I need to go back over these to figure out where we are exactly with expiration. It might be helpful if the parties want to do that, do their own calculations as well, so we can compare. I will try and have that information for Monday. Okay, all right, and so we'll go ahead then and conclude Mr. Benchif's cases at this point. Thank you. Okay, Mr. O'Brien, you wanted to go ahead, please?
Yes, the next matter we are ready to address. My apologies, I'm just looking for the case number. This is an.
Where's common is I got this big.
Hey, sir.
I know. And can I get a Henry pencil? That way, I promise not to stab myself or anyone.
Yeah, thank you so much, Captain. Be there.
Okay, I think we're ready to start. Thank you, everyone. Let's go on the record, or actually, Mr. Roy, did you have a chance to touch base with Ms. Carsonson? Did you need additional time to talk to her? I just want, no, okay. Okay, let's go on the record. All right, we're on the record. City, if you want to start us off, please.
Thank you, Your Honor. This is the city versus Mr. Benshu. There are several cases on the calendar this afternoon. I am just going to go through and name each of them. It is SMC cause number 656-748, 656-749, 669-329, 671-384, 675-405, 676-175, 676-207, 676-216, 676-463, and 676-492. And this is Morgan Karstensen appearing on behalf of the city.
All right, and thank you. Mr. Roy? Okay, so I guess let me just get some clarification. So Mr. Binshif, I know that you want to represent yourself, and I guess I'm not clear on whether that was actually approved by the court, so.
Well, my understanding is that under Washington Constitution, Article 1, Section 22, I have a right to appear, I have a right to call witnesses. It's inferred in that that I have a right to represent myself, as well as the Sixth Amendment to the U.S. Constitution. My right to counsel clearly includes my right to represent myself, per se.
Okay, so I'm not denying that you absolutely have the right to represent yourself, but I think what I'd like to do is just clarify for the record where we are, so there's no misunderstanding between you, current defense counsel, and the city as to who is doing what. So, Mr. Benchuv, why don't you do this first? So, is it your wish to represent yourself on these 10 pretrial cases?
Yes.
Okay.
And for the record, I'm here by special appearance. I objected to both personal jurisdiction and subject matter jurisdiction. So everything that's being said today is proceeding under that presumption, which we can address in a minute. But yeah, I have been trying to represent myself and dismiss these malicious prosecutions for, the last year and a half. And unfortunately, your associate judges prevented me from appearing to dismiss the cases. And unfortunately, the DPD repeatedly, against my express objections, both in writing and by voicemail message, kept filing notices of appearance and putting DPD attorneys as my counsel. So, that's not in any way my fault. That's
okay. So thank you. Okay, so Mr. Roy, I guess your understanding right now is that, are you still assigned to some of Mr. Benchuf's cases?
I'm going to give Mr. Roy, who's very polite, permission to answer those questions, even though he's not considered my counsel as far as I'm concerned.
Okay, I just.
So, Your Honor, now that all the parties are in the room.
Yes.
Procedurally, I was first appointed to 675-405. Mr. Binshuf was granted his pro se motion on that case. And sometime afterwards, I believe I was reappointed to all 9 other cases. So at the moment, my notice of appearance is filed on all 9 cases.
Okay.
However, as I've said previously, I do not have Mr. Binshuf's consent to speak on his behalf for those cases.
Okay. Now, do we know, so on the matter of, so Mr. Benchuf, I do want to, if you want to represent yourself, I'm not trying to stop you. What I'm trying to do is just make sure that we are clear about what's happening. So Mr. Roy, on 675, it was 675-405, where you said he was granted the right to represent himself. Is that?
That was the original case that I was first assigned to.
So what I'm looking for is to see if the court had gone through a waiver of right to counsel, and it's on, let's see that it's filed here. Let me just.
So, Your Honor, I do have one objection to what appears to be a formulaic statement there. By representing myself, I am not waiving my right to counsel. I still have a right to counsel. I am foregoing my right to have the Department of Public Defense represent me, but I'm currently attempting to speak with and obtain a defense attorney. I'm currently, and for the last month have been, denied the ability to even speak with a defense attorney of my choosing without having it recorded. So I'm pro se, but I'm not giving up my right to counsel.
Okay, so All right, so let me ask you this. Was there ever a time when a court went through if you're representing yourself, the procedure would be to go through a waiver of right to counsel to make sure that you understood all of the ramifications of representing yourself. So do you know if that happened?
That has happened before.
Okay,
Before Judge Mary Lynch in case number 656749, we had to go through that because I represented myself at trial in September 2021.
okay, okay. All right, so Mr. Benshu, okay, so I just want to make sure too that you understand, if we go through a waiver of right to counsel and I allow you to represent yourself, it doesn't necessarily, I mean, so you can't represent yourself and then not represent yourself. This has to be done with the permission of the court. Otherwise it gets very confusing because the city has to know who they're dealing with, whether they should be talking to you or talking to an attorney, because they can find themselves in a difficult ethical position if they think you're representing yourself, but in fact you have someone representing you. So do you understand what so everyone needs to be on the same page.
Well, I would actually find it refreshing if the city started comporting themselves as if they were concerned about their ethical behavior. Because so far, after 4 years, nearly 4 years, I've seen no evidence that the city, through its officials, cares about ethical conduct.
Okay, well, that's not exactly answering my question, but okay, Mr. Roy and Ms. Carsonson, what I am suggesting we do is I would like to go over the waiver of right to counsel with Mr. Benshoof, and then once that's established, we can proceed. So I just want to make sure, Ms. Carsonson, if you had anything you wanted to add before I do that.
The city has nothing to add. Thank you, Your Honor.
Okay, and okay, so let's do this. So Mr. Benshoof, you're familiar with this form just because I know that you went through it previously on a different case. So let me go through this with you. Okay, so right now you are charged with 2 counts of stalking, 1 count of custodial interference, and 86 counts of violation of a vulnerable adult protection order. And so I want to make sure that you understand that if you're found guilty on any of these charges, you could be facing a maximum penalty of 364 days in jail on each count and a $5,000 fine on each count. So do you understand that that's the maximum that could be imposed if you're found guilty on any of these?
I understand that if the city had jurisdiction, that could be a possibility, Your Honor.
Okay, so the city, okay, so do you think the city does not have jurisdiction?
I know the city doesn't. We can start all of these DV cases are derivative of case number 669329. I appeared on November 16th of 2022 by special appearance before Judge Willie Gregory. I informed Mr. Gregory that the city, through prosecutors Sahila Serafan and Katrina Outland, had failed to provide the city with proof of personal jurisdiction, specifically complying with RCW 35.20.270 subsection 1, which requires the city in issuing either criminal or civil summons to do it through the chief of police, a police officer under the direction of the chief of police, or the county sheriff, or a deputy under the direction of the county sheriff. That did not happen. In fact, the city has a custom and policy of supposedly obtaining personal jurisdiction via a USPS first class mail letter. That violates RCW 35.20.270. I have Katrina Outland signing her name in red ink in both state and federal court, admitting that it is the custom and policy of the city to violate that or said statute, because that's just how they do things. So that was the personal jurisdiction issue, and this has happened in all of these cases. Unfortunately, in that case, 669329, November 2022, Judge Gregory simply played the typical game, which is, well, if it happened within Seattle city limits, we have territorial jurisdiction, and because I'm wearing a black robe, and because I say we have jurisdiction, we get to ignore personal and subject matter jurisdiction. I hope that anybody who has attended law school and graduated knows that that is a bunch of baloney.
Okay,
Furthermore,
so Mr. Benshoof, hold on. Okay, so I understand that you are objecting to the city having jurisdiction on these cases. I understand that. So what I'm going to do is note your objection. Your position is the city doesn't have jurisdiction, but we're going to continue. So your
Right, but
objection
I
is
have one
noted.
more thing too, because I need to explain why the city doesn't have subject matter jurisdiction, and that is because the Seattle Municipal Court is a court of limited jurisdiction. It is not a court constituted under Article 4 of the Washington State Constitution. It's created under statute, specifically RCW 335. If you read RCW 7.105.050 subsection 1, parts A and B, it states unequivocally that in an allegation that I or someone else has violated a allegedly valid restraining order from family court, which is King County Superior Court, involving a minor child, which my son is still a minor, that only the Superior Court has jurisdiction to adjudicate the alleged violation of that statute. Not even King County.
So, okay, Mr. Benchif, please hold on just a moment. So I understand that your objection to the city not having jurisdiction, and there's a time for that. So if you're going to be representing yourself, which it looks like I probably will, but we need to get through this form, then there'll be an opportunity for you to ask for a motions hearing, to file briefing, and to argue the
I object,
jurisdictional.
Your Honor, because jurisdiction is a threshold matter. I object to the notion that the city gets to proceed with arraignment and proceed under the presumption that they have jurisdiction, because I've explicitly challenged it on the record, and I've been challenging this since November 16th of 2022, and yet the court has proceeded in violation of 18 United States Code Section 1962, Federal RICO, violation of my rights under 18 U.S.C. Sections 241, 242, and enough is enough.
Okay, so Mr. Benchif, I'm noting your objection, and again, I'm going to tell you that you have an opportunity to brief this and argue it later, but we first need to establish if you're going to represent yourself. So my next question for you is that is your decision to represent yourself voluntary on your part?
Yes,
Okay, and then sir, what's the last grade that you finished in school?
I have a high school diploma.
Okay. And then, sir, it appears that you do, but the question is, do you speak English fluently?
Hopefully.
Okay, that sounds like a yes,
Yes.
as I'm able to converse with you today. Have you ever studied criminal law?
And I find study.
Okay, do you want to tell me?
I haven't done any formalized schooling study.
Okay, but it sounds like you've done some informal study though, then?
Yeah.
Okay. Okay, so Mr. Benchuk, have you ever represented yourself or any other defendant in a criminal action? So you'd mentioned earlier that there was a case where Judge Lynch was the judge.
Yeah.
Yes.
Settlement Court case number 656749, September of 2021.
Okay, I'm sorry. It was 656
749.
749. Okay, thank you.
Which was itself a malicious prosecution in violation of the Civil Rights Act of 1964 and seminal civil rights cases such as Ham v. City of Rock Hill and State of Georgia v. Rochelle.
Okay, again, that's noted. All right, Mr. Benchuk, do you understand that if you're not a United States citizen and you're found guilty of a crime, you could be deported, excluded from admission, or denied naturalization?
I understand that statement.
Okay, thank you. All right, and then do you realize that if you're found guilty of more than one crime, the court can order that sentence to be served consecutively, meaning one after another? Do you understand that?
Yes, Your Honor.
Okay.
Sorry, it's hard not to laugh at the thought of 89 consecutive charges relating to me texting with my son and dying in King County Jail. It's so preposterous.
Okay, you don't need to explain, sir, you don't need to explain. Okay, let me get on to the next question. Do you realize that if you represent yourself, you are on your own and the court cannot tell you how you should try your case or advise you as how to try your case?
Yes.
Okay, thank you. All right, are you familiar with the rules of evidence?
Someone.
Somewhat, okay. All right, are you familiar with the rules, or excuse me, so I also need to make sure that you understand that the rules control what questions can be asked of witnesses, how questions must be phrased, and what documents or other items can be admitted at trial. And in representing yourself, you must follow these rules, and these rules apply in the same way they would apply to an attorney. So do you understand that, sir?
I understand the statement. I would say from personal experience that the attorneys have violated the rules on a regular basis, as have judges, but I follow the rules.
Okay, so this is about you. So you understand though that you're held to the rules of evidence, correct?
Yes.
Okay. All right. Are you familiar with the rules of criminal procedure?
Absolutely, yes.
Okay. Okay, and then let me read the following. These rules govern the way in which a criminal action is presented in municipal court, and they control the presentation of the case. These rules apply to you the same way they would apply to an attorney. So I want to make sure that you understand that.
I understand.
All right, thank you. All right, and let's see, do you realize that if you decide to take the witness stand, you must present your testimony by asking questions of yourself, and you must proceed question by question through your testimony. So the prosecuting attorney has an opportunity to object before each question is answered. Or more simply put, you cannot just tell your story. So do you understand how that would work if you were to take the stand?
I do understand, and last time I tried to take the stand, I was denied that right by Judge Lynch, for the record.
All right. I'm moving on. Do you realize that an attorney would be familiar with the rules of evidence, skilled in following the rules of criminal procedure, and could advise you of possible defenses to the pending charges?
I do.
Okay, thank you. All right. Do you realize that if you proceed without an attorney and you do not properly present a defense, subpoena witnesses, or otherwise represent yourself in a competent manner, you will not be able to obtain a reversal of a conviction on the grounds that you received ineffective representation?
I do.
All right, thank you. Okay, and then just briefly, sir, why do you not want an attorney?
I didn't say I don't want an attorney, Your Honor. I don't want an attorney who works for the Department of Public Defense.
Okay, and can you tell me then maybe why you don't want an attorney from the Office of Public Defense?
Yeah, because they are constrained apparently by their superiors from offering competent defense representation. For example, their customs policies, practices, and procedures preclude them from filing a habeas petition on my behalf, even when I've pre-written it for them. From prior experience, I also know that even in the case where the city had destroyed the exculpatory evidence in violation of Brady v. Maryland, that even when I pre-wrote a motion to dismiss, that the policy of the DPD was to not file that, nor even argue it. So unfortunately, the DPD is not set up and does not operate in a manner that I find to be effective counsel.
Okay.
I don't have any problem at all with Mr. Reagan Roy as a person. I think he's a good person, but I think he's limited by what he is allowed to do in relation to his employment.
Okay, so I see what you're saying. So okay, so you're choosing not, you don't want a DPD attorney, and then you want to represent yourself now, and then you've also indicated that you may hire private counsel.
Right.
Okay,
I
okay.
expressly reserve my right to hire outside counsel.
I understand.
But as I said before,
Mhm.
I have been denied the right to even communicate with a potential attorney without having the call recorded.
Okay, so let me back you up just one moment. So I want to make clear, if I allow you to represent yourself, that's fine. And again, I want to repeat what I said earlier. The city will then be communicating with you directly.
Yes.
If you hire private counsel, that person needs to make a notice or file a notice of appearance, in which case the city would need notice, and then they would know that they would not be able to be in communication with you. Okay, so everything has to be on the record so that everybody understands what's going on. Okay, all right. And then let me move on. Do you realize that once you waive your right to an attorney, it is discretionary with the court whether you may withdraw the waiver? So.
Well, I'm waiving my right to have the DPD represent me. I'm not waiving my right to counsel.
Okay, I think this question really means that if I allow you to represent yourself, that so that's a waiver of your right to counsel is what we're going through. So it has to be, I think it's basically, it's discretionary with the court to allow you then to switch back and have someone representing you. It's kind of like what I was just saying. I just want to make sure that we're all on the same page. If you hire counsel, the court's going to need to know that that's happening.
I understand. It sounds like you're reading from a city-produced form and that you're going through that. And I understand that that's how it's written and.
No, this is a court form, sir. We use this, it's a court form.
Right, but it's a court form for Seattle Municipal Court, which is a court of limited jurisdiction, and I've already articulated numerous instances how Seattle Municipal Court violates the law, so.
Okay, so Mr. Bench, how do you want me to answer that question? So let me read it to you in that, because I don't want to put words in your mouth. So it says, do you realize that once you waive your right to an attorney, it is discretionary with the court whether you may withdraw the waiver? And so
I understand that's the court's position, right?
okay. All right.
I hope the court understands that my objection to the lack of jurisdiction means that the court doesn't actually have authority to do anything.
Okay,
But for the sake
I
of
understand. And I did earlier say that I was noting your objection that you would have an opportunity to brief and argue your position on lack of jurisdiction at a later time.
There is an issue with my gulag incarceration in King County Jail, which is I have no access to pro se materials. I have no access to the internet. I have no access to a computer. I have no access to a printer. I have no access to even a single piece of paper. It's not scratch paper that I've stolen from somewhere else, basically. Not stolen, but reappropriated. I have no access to envelopes. I have no access to stamps. So while you several minutes ago mentioned that I need to make sure that I put stuff on the record, for the record, I am unable to put anything on the record because of the incarceration conditions. They've kept me for more than a month on floor 9, which means that I don't even have access to anything at the commissary. So even if someone put $1 billion on my books, there is no way for me to get an envelope from the commissary to my room so that I could put a piece of paper in it to mail back to the Washington Supreme Court, which has already sent me legal mail, as well as the U.S. District Court has.
Okay, well, at this point up till now, I don't think that because you have not been formally representing yourself, I'm not sure. Well, okay, so Mr. Benchiff, hang on just a minute. Okay, all right. So I understand that you haven't had access to research materials, things to brief. So if you're going to be representing yourself, then going forward, we will have to address that. So
yeah, and so page 26 of the inmate, the King County inmate booklet says that in a criminal case, the judge will issue a court order permitting you to act as your own attorney or pro se, and then I must use a white kite to submit a copy of the court order to inmate management services. I've gotten multiple excuses from King County jail staff as to why I haven't been afforded pro se materials and services, but I would ask that the court at minimum today issue an order with all 10 of those case numbers on there stating that I have pro se status so that the jail can't any longer deny me access to materials.
okay, so yes, so once this happens, they will be notified that you are representing yourself. Okay, so Mr. Benchiff, we're almost to the end here. Let me finish up the last few questions. Do you realize that while the court may provide you with an attorney as a legal advisor or standby counsel, you do not have an absolute right to such assistance, and you, not a standby counsel, must prepare for trial? Okay, so were you asking for standby counsel? I didn't hear you say that, so okay, that's fine. All right, and then have any threats or promises been made to you to induce you to want to represent yourself?
No.
Okay, now, in light of the penalty that you might suffer if you're found guilty, and in light of all the difficulties in representing yourself, Is it still your desire to represent yourself and give up your right to be represented by by an attorney from the Department of Public Defense?
Yes.
Yes, okay. And then one last thing, is this decision entirely voluntary on your part?
Entirely, yes.
Sorry? Yes, okay. All right, thank you. Okay, and so, okay, I'm just gonna note that I went over this verbally with you, Mr. Benshoof, today. All right, so the court, having gone through the waiver right to counsel of Mr. Benshoof, is going to allow him to represent himself on the 10 cases. So, Mr. Roy, I want to, let's see, if you want to go ahead and withdraw, if you have notice on any of these, but you may go ahead and take off, so thank you.
And just for the record, last time I wasn't in jail, and I checked the municipal court's website. It had, there was still Mural Serkan or Cyril Mercan, I can't remember what her name, you know her name. I think one of Mr. Roy's supervisors, even though she told me in writing that she had formally withdrawn from one or more of the cases, those 10 cases, when I looked on the municipal court website, it still had her name listed. So I would just ask that the court ensure that the municipal court web portal will accurately reflect on all 10 of those cases, that I'm pro se on all 10 of them, make sure that
so
names are all removed.
Right. Mr. Roy, I'm sorry, Ms. Sirkin is, and you and Ms. Sirkin are with, I'm sorry, which agency?
Northwest Defenders.
Oh, okay, thank you. So if you could just make sure that Northwest Defenders Association is withdrawn from all cases, and then if there's nothing else, Mr. Benshoof, I'm going to let Mr. Roy go.
Yep.
Okay, thank you, Mr. Roy. Okay, and then lower bench, a copy of that will need to be filed on each matter. Okay, now. Okay, so. All right, so Mr. Benshoof, now we are at the pretrial stage on your cases. So what would you like to do today? So you probably already know this. The general options are you can the case is set for trial, or you can ask for a continuance if you need more time to prepare, investigate, negotiate with the city.
Well, as I said before, the court doesn't have jurisdiction to proceed. The court doesn't have jurisdiction to set a motions hearing. Everything that's been going on is a malicious prosecution violation of RS 59.62.11.
Okay.
So I know, are you familiar with the lawsuit that I filed in federal court, which named most of your contemporaries, including,
I am familiar.
So your name was listed in that, in the statements of fact, but you were not named as a defendant. You were one of the first judges that presided over a hearing which I wasn't even allowed into, which happened in the fall of 2020. And the same thing that has happened with these DV cases, namely lack of personal jurisdiction, lack of subject matter jurisdiction, happened back then. I don't actually have any animosity towards anyone, even the people who have pushed my son to the point of suicide and destroyed my church and retaliated against me for more than 4 years. I merely want the violations of law to stop. I want my rights to be respected because, like a chain, you know, it's the weakest link. If If we allow the city and the county to violate my rights, then it's basically a green light for them to violate anybody's rights. You know, it's hard for people to even imagine that I'm still being prosecuted for the fact that I was grocery shopping for my son and I to buy organic groceries without covering my face in 2020. It's, the city could not legally prosecute me. I've already cited Supreme Court case law, and I've argued that in court. So those cases, the court never had personal jurisdiction. The court was violating the United States Supreme Court case law as well as the Civil Rights Act to prosecute me for trespass, for shopping without a face mask. Both case number 656-748 and 656-749 should be dismissed. Technically 656-749 because there was a trial that should be vacated, which is required pursuant to Supreme Court case law.
So, Mr. Benchoof, now that you are representing yourself, and you've made an oral motion to dismiss the cases, which I'm not going to do at this time, but you will need to, if the procedure we're going to follow is if you want to set these for a motions hearing, we'll set it for trial, and then we'll set a motions hearing. And at that time, you can argue for dismissal based on what I'm hearing is your perceived lack of jurisdiction. But today, though, you need to make a decision if you want to ask for a continuance of the cases or if you would like to set the cases for trial.
Well, so I understand that's the binary that the court tries to railroad innocent people through, but it's my interpretation of what a court is constituted to do is you're the judge, you're supposed to be an impartial trier of fact. The prosecution, I'm not sure what Morgan's last name is because I can't quite make out how to spell her last name, but the prosecutor is required to provide evidence of personal and subject matter jurisdiction. If the prosecution has not provided evidence of jurisdiction, it's a threshold matter, the court may not proceed. And that's why I have argued, and that's why in federal court lawsuit, I articulated that the city has been engaging in a RICO enterprise. Because without personal jurisdiction and without subject matter jurisdiction, when Judge Gregory and others issued warrants between $10,000 and $250,000, that was attempting to exercise unauthorized control over more than $5,000 of my money, which is a Class B felony under RCW 98.56.030, as well as extortion, RCW 98.56.120. Okay.
Okay,
So you can set a motions hearing if you want to. Will I come here if I'm still in jail because I'm being forced to? I will. I'll do it under objection.
Okay.
And we'll speak respectfully and we'll do all that.
Okay.
But I don't agree to the court having jurisdiction.
I understand that. Okay. So, okay. It might be best, well, Ms. Carsonson, let me hear from you. I think it might be best to go ahead and set the cases for trial today, but the city, do you want to weigh in?
Yes, Your Honor, thank you. I appreciate that. The city doesn't necessarily have a position on whether it gets set for trial or is just a continuance. I happen to agree with Your Honor. It seems like perhaps setting for trial is the best way forward in getting a motions date. I do have some availability for Ms. Outland, and just so all the parties here are aware, I'm merely the covering attorney this afternoon. These cases are not assigned to me, but I do have authority to set them for trial.
Okay. All right. So, Mr. Benchoof, let me put this to you. I know that you are disagreeing with everything that's happening procedurally today, but I'm still going to need an answer from you since you are now representing yourself. Would you prefer to continue these cases, to talk with the prosecutor handling your cases, or would you prefer to set the cases for trial today?
If those are the only two choices, I will never, I do not wish to forego my right to speedy trial.
Okay.
I do not wish to have a continuance.
Okay, I understand.
I am more than happy to engage in dialogue with the prosecutor's office, and if they need to be educated on why they don't have jurisdiction, I'm happy to walk them through that. But I think the most important issue right now is that I am being unlawfully restrained and detained in King County Jail. I'm not a flight risk. I've lived in Seattle my entire life. And I've done everything I can to try to resolve these issues through the courts. So.
Okay, so Mr. Bench, let's stay on track with just the
Okay.
issue of, there are many things that you are objecting to and disagree with. I understand. But so let's do this. So in terms of, I've heard you say you don't want to waive your speedy trial right. I get that. So that means that we should set the cases for trial today. When we set the cases for trial, then you are still free to talk with the prosecutor handling these cases to to see if you can resolve them and or prepare further for trial. So that's your option. So what I'm going to do, I was looking at the cases just to figure out where we are with expiration. So on all of these cases, Mr. Benchoof was either arraigned or made first appearance on July 5th, 2024. So bail was set. And so, wait, hold on just a moment. And so my calculation was that expiration was originally set 60 days from July 5th, and the court set it at September 3rd, 2024. And then let me finish. Subsequently, there were 2 hearings where Mr. Benchoof did not appear for hearings, and so the court excluded time. That would be a total of 19 days. And so by my calculation, expiration would be 19 days past September 3rd, which falls on September 22nd, 2024, which is a Sunday. And so then to adjust for the weekend, that would take expiration to September 23rd, 2024. Okay, so hang on one moment. Okay, so Ms. Carstensen, what's the city's position in terms of expiration on these cases?
Yes, Your Honor, the city agrees with the court's analysis, including the exclusion or refusals, and does believe that expiration would be on September 23rd, 2024.
Okay, Mr. Benchoof, would you like to weigh in on the expiration date, sir?
Yeah, I object to the city's position on that as well as the court's.
Okay.
Because first of all, to back up, I was arraigned on case number 669329, supposedly on November 16th of 2022. I was supposedly arraigned for case number 656748 back in 2020. And my right to speedy trial was violated by a former Northwest offender, Crystal White, back in 2020. As far as the current alleged tolling, I would object to that first and foremost because I have been denied the right to appear in court unless I allow my religious beliefs to be violated. Specifically, I have been denied the right to wear my religious vestments upon my head. And after 4 weeks, nearly 4 weeks of filing complaints with the jail staff, they gave me a head covering, which I believe is called a kufi, which is of the Muslim faith. I am not Muslim. The only reason I am here today in the court is because I allowed my religious, I basically gave up my religious expression and freedom to come here.
Okay.
Because I felt it more important that I get things on the record and let the court know that the retaliations in jail continue, that I was put in the psych ward yesterday by one of the jail staff who has been forcing me to wear a Muslim kufi to have my rights respected and be served food.
Okay, so Mr. Benchoof, let me stop you there again. Okay, so I'm going to note your objection to the court setting expiration at September 23rd. I think you've made a pretty clear record of your position and why you weren't here at the last 2 hearings. So that is all noted. And so at this point, then I'm going to use that as the expiration date. Ms. Carstensen, do you have a trial setting order? Or let's see, I'm not sure. Yeah, usually the trial setting order is generated by defense, but I don't know if the city is able to do that.
I don't know, Your Honor. I can log into Adobe right now. I should be able to generate such an order. If you could just give me a few minutes, I'm happy to look into that.
Okay, why don't you do that? Thank you.
So,
Thank you.
question, Your Honor, is the court proceeding under the presumption that all of those cases would be consolidated and tried together? Because I don't agree to that.
Well, what I'm going to do is set them for now together. If you want to make a motion to have them set separately, then that, I will leave that to you to do that. So we need to have a starting point. Let's see, actually, Ms. Carsonson, I know you're working on the trial setting order. Let me find out. So Mr. Ben-Shuf sir, I just want to make sure I understood. Were you asking for a separate trial date for each case?
Yes.
Yes, okay. And what's the city's position on that?
Your Honor, logistically, I'm not sure how feasible setting each of these trials separately is. Ms. Outland would be responsible for prosecuting these trials rather. And we need preferably 4 weeks to send subpoenas out to the city's witnesses and give the city and their witnesses enough time. And with that in mind and the amount of cases that Mr. Ben-Shuf has, I don't know that it's possible to set a trial every single week before expiration runs out. So I think the best way to do this is to set all of the cases on essentially for the same date. And additionally, because I'm not familiar with these cases, I can't really speak to the facts that would support either joinder or severance at this time. My argument is solely based on the amount of cases and the expiration date and how actually feasible possible it is to try these cases separately.
Okay, all right. So Mr. Ben-Shuf, what's happening then? It's just because we have the expiration on these cases is September 23rd. There isn't enough time to assign a separate date to each case. But I want to make sure you understand, by setting these all on the same date, it doesn't mean they'd all be tried together. They would still be separate cases, but for the time being, because they can only be tried one at a time, we're just giving them a date for now with the same trial date.
I understand, Your Honor, and for the court's information and the prosecution as well, as far as the DV cases go, 669329 was the progenitor of all the other DV cases. That the dismissal of that case, which is an inevitability, will basically vacate all of the other DV cases. So while it may seem daunting to the court right now that there's so many potential cases, that one case will resolve all of the other cases.
Okay. We've had other people with multiple cases too, so it does seem a little daunting. That's true, but I think we'll be able to manage. Okay, so we'll get these all set for the same date. Let's see. In terms of dates, so September 23rd expiration. So, Mr. Ben-Shuf, well, let's see. Let me hear from the city first in terms of Ms. Outland's availability prior to September 29th.
Yes, thank you, Your Honor. Ms. Outland did not indicate that she had any availability between now and September 29th. I'm sorry for getting a little off track here, Your Honor, but in order for me to finish the trial setting order, I will need an email to send to Mr. Ben-Shuf. It's part of the Adobe kind of required boxes.
Okay, Mr. Ben-Shuf, do you have an email address to which the city can send the trial setting order?
I do, but I have no access to a computer, so.
So I think what we're going to have to do is, so it'll be sent to you. Well, let's see. Ms. Carsonson, I, 'cause don't know if the city has a suggestion, or, Ms. Carson's, I have an idea. Maybe
Okay.
are you able to generate a trial setting order that we would be able to just, like a blank one that we could print here in the courtroom?
What I think I could do is perhaps put, I can put the lower bench and your honors email.
Okay, that might work.
Okay, and then, your honor, your email just follows the standard, pattern for the rest of court personnel. Is that correct?
So no, it's actually, so it's a little bit different. It's andrea.chinsmc@seattle.gov.
Okay. And I am finishing that up. I just need to put in the case numbers, and that's just going to take a few minutes just to make sure I have all of them in that trial setting order.
Okay, that's fine.
Would you like us to print those ones that come to us? Or if they do come to us, then you can sign them in person, or how would you like?
So they're all going to be on one trial setting order.
Okay.
And so, yes, since we have Mr. Benshouf here, we can just go ahead and have him, we'll just do a paper. Yeah.
So, Your Honor, I'd like to make an oral motion, given the fact that I've been held pre-trial for more than a month, in large part incommunicado. I've been denied a probable cause hearing in most of the cases. 669-329, I was never afforded a probable cause hearing. Judge Gregory skipped right past probable cause and claimed the court had jurisdiction. In the subsequent case, when Faye Chest issued a $1,000 arrest warrant, 671-384, there was no probable cause hearing. It was an ex parte hearing between Prosecutor Katrina Outland and Faye Chest, in which I know for a fact, as a firsthand witness to the facts of this case, that Katrina Outland knowingly and willfully made false statements and misleading statements, which is a violation of RCW 90.76.175. I would like a probable cause hearing so that the court may issue an order allowing me to leave without to be out of jail while I defend myself.
Okay.
Because trying to defend myself with all of these cases, even if King County Jail staff were affording me all of the pro se materials, they still only grant me a maximum of 2 hours, 2 times a week at a computer. And I think that would be a great miscarriage of justice and due process when we have the city with all of its resources and staff and me stuck in a jail with a 2-inch pencil that doesn't have an eraser and only 4 hours maximum best case scenario per week.
So,
I'm not a flight risk. I'm a risk to nobody.
okay, well, Mr. Benshouf, okay, so there was a probable cause was made at the time, either the warrants were issued or when you were arraigned. And so I'm not going to revisit that. And the court had concerns about commission of violent crime if you were released. That's why they set the bail. And so I'm not inclined to release you at this time. I understand it's going to be harder to prepare in custody than if you were out, but
I'm an absolute pacifist, Your Honor. I've never spanked a child.
okay, just hold on. So the court's already identified concerns and listed them for why the bail was set as it was. So the motion for a release is denied at this time. The probable cause was established as far as the court can tell and looking at all the court records. So so the motion's denied. We are going to go ahead and set the cases for trial as soon as we have a trial setting order.
And Your Honor, I did send that. I think it made its way to the lower bench.
Okay, thank you.
I would just like to note my objection for the record, which is that Katrina Outland has repeatedly made false statements to the court regarding Jessica Ray Owen. Katrina Outland knows full well that Jessica Owens, attorney Nathan Kleiber, suborned Ms. Owens' perjury to fraudulently initiate in County Family Court Case number 21-5-00680-6, collateral and extrinsic fraud, that every order out of that court case was void ab initio, that I was denied due process, the right to trial by jury, the right to appear in front of witnesses, and that Ms. Outland is knowingly and willfully conspiring with prostitute perjurers to try to maliciously prosecute me and unlawfully imprison me.
Okay, so Mr. Benchif, again, that's noted. You will have opportunity to argue this at a future date. We set a motions hearing. Okay, so I have the trial setting order in front of me. This is for all 10 cases. The court's noting expiration at September 23rd, 2024, to which the city is in agreement and to which Mr. Benchif is objecting, and so that is also noted. Okay, now as far as discovery, okay, I know that discovery is incomplete because the court just allowed Mr. Benchif to represent himself today. And so the city is going to need to provide all of that. Let me just make a note.
And I would further object to being incarcerated because my trying to interview witnesses, which one of them would be city star witness to the perjuring prosecuted by the name of Jessica Ray Owen. And I can't see how the city is going to set it up so that I can interview Miss Owen and record it and get transcriptions.
You know, sir, I can't answer that at the moment. We're going to have to work through this though, because, yeah, because we'll just have to figure this out moving forward, but your objection is noted. Okay, so I've noted discoveries incomplete because the court allowed Mr. Benchif to represent himself today, August 5th, 2024. Okay, now, Mr. Benchif, this is your opportunity to set a motions hearing if there are motions that you'd like to make. You've noted several orally, so do you want a separate motions hearing, separate from a trial date?
I would like a motions hearing.
Okay.
At the earliest possible time.
Okay, let me do this then. It's easier to set a trial date and then to then set a motions date once we know what the trial date is. Okay, so Ms. Carstensen, in terms of, there are a lot of cases here. So in terms of the city's preparation for them, I guess, do you want to suggest a trial date?
Yes, Your Honor. If expiration is on September 23rd, the city would suggest a trial date of September 15th.
Okay, Mr. Benchif, do you have a preference for a trial date?
No.
You do not? Okay, all right. So I think then what we'll do, since
I mean, other than
And I apologize, Your Honor, that would be September 17th, a Tuesday. I'm not sure why I said September 15th.
Yes, okay.
Would need to ask for permission to oversend that.
Oh,
Your Honor, I would still note for the record that alleged defendant would request a trial date in August because my position is that the city should not be tolling those 17 days that I was denied the right to review.
okay. All right. So, sir, I will note that. Lower bench. The court is going to authorize an overset because because of the timing of expiration and also the large number of cases that we are dealing with for Mr. Benchif. So it would the difficulty in setting it any sooner. So, lower bench, do you need anything else to do that?
My only question is, there's 3 matters that don't currently have the TV flag on them. Would you like to list all matters as TV, or would you like to those as just regular poster?
Ms. Carstensen, do you know if Ms. Outland is also handling the 3 non-DB cases?
I do not know for certain, although I believe that she is.
Okay,
So it's all the same.
Your Honor, I would also object to the basis for the court's decision in that the quote-unquote difficulty of setting that many cases for trial is not superseding a right to a speedy trial. And if that's the court's position, I'd like to note my objection for appeal.
yes, your objection is noted, and I will also, again, note that the court set expiration at September 23rd and is going to maintain that date, so we're going to get all of these set prior to that date of September 23rd. Okay, so lower bench, sorry, okay, let's see. Lower bench, did you need anything else to authorize an overset for September 17th? And in terms of, yes, so you can, the non-DV cases can go on the general calendar, that's fine. It just, we'll know that Ms. Outland is handling all of them.
And I wonder, do we need to have presiding? We just need to check with the presiding.
Okay.
to authorize that.
Okay.
Besides that,
That's fine, okay.
Thank you.
And I would also like to note an objection to Miss Katrina Outland or Miss Segula Seraphan having anything to do with these prosecutions going forward due to their conflicts of interest, which I will address at the motion screen.
Okay. Lower bench, when you were contacting Judge Chess about the overset, can you just let her know too that's timing concern with the 10 cases and
Said yes, Your Honor.
okay, thank you.
Your Honor,
Sir.
when we get to scheduling the motions hearing, I would also like to inform the court that I wish to have an evidentiary hearing held because the search warrant that was obtained by SPD Detective Brian G. Ellis was neither sufficient. There were sufficiency problems as well as showed a reckless disregard for the truth. And because that search warrant was used to unlawfully arrest me and destroy my home, my present incarceration is unlawful.
Okay, so what I'm going to do, Mr. Benshoof, so there's on this trial setting order, I'm asking you, I'll ask you the nature of the motions that you plan to address at that hearing. So one of them is, so you're saying the insufficiency of the warrant.
Yes.
Okay, and then do you want to list for me the other types of motions that you're bringing for that hearing?
Yeah, well, I think pretty much everything can be addressed under the rubric of motions to dismiss. All of the DD cases, as well as I believe it's case 675405 or 676405, which was the alleged looting of a police vehicle, which isn't technically DV, but it's derivative of 669329. All of the DV and derivative cases will be addressed under one motion to dismiss.
Okay.
That's hearing for simplicity.
Okay.
And then the 656, 748, and 749 will be addressed under another motion to dismiss. And for the efficiency of the city prosecutor's office, they might just want to contact civil attorney Dallas Lake Pierre because he's already seen all of my arguments and I've already seen all of his arguments. And the writs of prohibition that I sought in King County Superior Court are currently at the Washington Court of Appeals under case number 86466. 1-5.
Okay, well,
So
Mr.
we're
Bench,
actually dealing with new material.
okay, so Mr. Bench, the city will only be dealing with you, so they're not gonna be contacting any other attorney on your behalf, so that would be inappropriate at this point, but I did wanna make sure that I noted this how you wanted it, so it's, so you're gonna be talking, on one of the cases, insufficiency of a warrant to arrest, and then motions to dismiss for the various reasons that you set out, okay?
Yes.
All right, and then city, any motions that you wanted to note?
At this time, Your Honor, I don't know if Ms. Katrina has any motions that she would like to note. The city would ask that 3-5 be reserved for trial, and I would just make a general reservation for Ms. Outland if she has any motions that she would like to.
Okay.
Your Honor, I should make a correction for the record,
Mhm.
because technically, 656-748 should be addressed as a motion to dismiss, and 656-749 should be addressed as a motion to vacate. Since there was a trial.
Okay, well, okay, so just, at this point, just sort of I appreciate that, but, so when you get to the motion state, at that point, I'm hoping that you will have, briefing, and I'm going to set a briefing schedule now, so give me just one moment. Okay, lower bench, let's see, we've got our trial date September 17th, so let me know when there is a motions date available.
And would you like to keep this in DB court as well?
Yes.
We have the 3rd, the 9th, and the 16th.
Okay, the 3rd, the 9th, or the 16th. City, do you want to, do you have a preference?
The city would request the 9th, Your Honor.
Okay, Mr. Benchoof, do you have a preference for the motions date? City's preference would be for the 9th of September.
Well, as I stated earlier, as soon as possible, so the 3rd, because I'm being unlawfully detained.
Okay, let's see, would the city be, so let's see. Ms. Carsonson, would the city be able to do the 3rd of September?
I suppose, Your Honor, I think the only concern that the city has is that is barely, technically less than a month away, and if the city needs to obtain any witnesses for that hearing, it's starting to get into a notice issue for the city. However, if the court is inclined to set it for that date, the city has no availability concerns that they're aware of at this time.
Okay.
One clarification, is the prosecutor's office suggesting that they may be calling witnesses for a motions to dismiss hearing?
Mm-hmm. Well, the city is also, well, okay, hold on just a minute.
Or did I miss, the city is also bringing motions?
And Your Honor, I believe in addition to the dismissals, Mr. Benchoof mentioned some warrant issues. So I am just anticipating the types of motions that are going to be filed, and I think the city does need to be prepared to subpoena witnesses.
Right. So Mr. Benchoof, it really depends on what your briefing says, what the city receives from you to determine if they are going to need to subpoena witnesses. But what I'm going to do, since your preference is for September 3rd, and the city is not aware of a scheduling issue, I know that's a little bit of a tight timeline. I'll go ahead and schedule the motions hearing for September 3rd. That's a Tuesday, 2024 at 1:30, and I'm assuming we could put it back here in 10:03.
Yes, Your Honor.
Okay, and then give me one moment. Let me set a motion or set up a briefing schedule. Okay. All right, so Mr. Bench, if we have the motions hearing on September 3rd, that would mean that your brief would be due on August 13th, and the city's brief would be due August 26th. Okay, so let me.
And
go
I'm
ahead.
sorry, Your Honor, you cut out a little bit. Is defendant's brief due August 13th?
Yes,
what you
August
said?
yeah, so August 13th for the moving party, August 26th for the response.
Thank you.
And Your Honor, I don't have any phone number by which to contact the prosecutor's office. So if the prosecution is open to pretrial dialogue regarding resolution, local resolution of these charges, I would ask that the prosecution provide me with a phone. And that it needs to be a direct line, because if there's a phone tree that I get into calling from the jail phone, I can't call them.
Okay, so let's see, Ms. Carsonson, can you provide a phone number for Mr. Benchouf to speak to Ms. Outland?
Let me see if I can locate that, Your Honor. One moment.
Okay.
I do have an office number. Would you like me to just provide it on the record?
Yes, so Mr. Benchouf, it looks like you've got some writing materials there. Okay, go ahead and read that into the record.
Yes, Miss Outland's office number is 206-684-7756.
That cut out.
Oh, I'm sorry, Ms. Carsonson, would you repeat that?
775.
6. So in total, it's 206-684-7756.
Lower bench, can you hand me the trial setting order I just printed? Thank you. Thank you. Okay, so what I'm going to do is have Madam Bailiff bring this around so Mr. Benchouf can sign. Ms. Carsonson, with your permission, can I indicate on the trial setting order that, or I don't know how you want to do this, that city approves via WebEx or something along those lines?
Yes,
Since-
that's fine. Yes.
Okay. Okay, and then, yes, so if Mr. Bench can sign it, we will, that one. Okay. Okay, so Mr. Bench, all I need is your signature at the bottom of this page, and then we will be able to conclude the hearing today. He is.
For the record, I still don't agree to the court's jurisdiction. Since I'm incarcerated, I'm not understanding why the court needs my signature to appear when I'm being incarcerated.
Sir, if you don't want to sign it, it's okay. It's standard procedure, just to make sure that you acknowledge that the cases are set for trial and that you understand that this is what the trial setting order says.
Okay, so just to show respect to the court, for the record, I understand the court has set the trial date against my wishes, and that the court has set a motions hearing for the 3rd, and so I acknowledge that those were set by the court.
Okay. You know, if you prefer, what you could just, if you write on the line where it says defendant, you don't put your name, you could just say acknowledged by, instead of agreeing to it. That's fine. All right, so we've got the cases set for trial now. Let's see, Ms. Carsonson, anything else from the city?
I do not have anything else from the city or for the city, Your Honor, and I actually do have a meeting at 4 p.m. as well.
Okay, I think we're just about done.
Okay,
Mr.
perfect. Thank you.
Okay, all right, Mr. Bench, anything else, anything new that you haven't brought up yet before we conclude the hearing?
I think I brought up enough today, Your Honor, and I appreciate your patience.
Okay, all right, sir, thank you. We're going to conclude your hearing then, and thank you, Marshals. Mr. Marshall. Yes, okay, Ms. Carsonson, you can go ahead and disconnect from the call. Thank you.
Thank you so much. Have a good day, everyone.
You too. All right, we can go off the record.
Once again, gotta go back.
From the motion calendar, number 1, bench shoe. This is State of Washington versus Kurt Benchu, 41026807, Seattle Resignation, Dale Charlton for the state. Council is present, and I understand defendant refused.
Good afternoon, Your Honor. James Coates, Northwest Defender is returning a record in Mr. Bench's case.
And Your Honor, given that we have now received your report, an opinion that Mr. Benchu is competent to proceed, I am asking the court to order reasonable force to transfer Mr. Benchu to court tomorrow at 1 p.m. And set this over till then. This is the second time he's refused on this calendar. And given the content of the competency report, which will report for filings,
Just briefly, we would oppose the issuance of a drag order in this case. I'm planning to go over to the jail this afternoon. I can attempt to speak to Mr. Benchu and see if we can avoid the drag order.
I'm going to go ahead and sign the drag order. It, of course, force months used if there's a green order, so hopefully that will occur, but I think you need to. So thank you.
Thanks.
From the motion calendar, number 1, Benchu. In custody.
Thank you.
Can I have a pen, but I promise not a pen. You have a pen?
Not.
Can you procure one?
Yeah, this is State of Washington versus Kurt Benchu. That's cause number 24-1-0-2680-7 Seattle designation. My name is Pat Clever, I'm representing the State of Washington. Representative is President and Custody Representative.
And good afternoon, I'm James Coates, Northwest, and there is attorney of record in this case. It's Mr. Benchu's desire to proceed on this case right now.
Well, first, I have asked for a competency evaluation. We do have a competency report that's dated August 1st, 2024. It offers the opinion that Mr. Benchu is competent and is able to proceed. Unless the parties want to be heard further, I would make that finding initially, and then we can go to the next. They want to be heard on that? Or
No, thank you.
okay, and Mr. Coatsworth, I saw you nodding your head. You agree that your client is competent?
I have nothing to add.
Okay, so I'm going to make the finding that Mr. Benchu is competent and that he can make his own decisions on this. Now, where we had started at one point at arraignment was Mr. Benchu had said that he wished to represent himself. And so, Mr. Benchu, I don't know if you still want to do that, or if that's what you want to address today, but I'm happy to start asking you some questions about that today, if that's what you wish to do.
Yeah, if the court would like to do the colloquy or whatever you call it, I'm prepared to proceed with that. And then after the court recognizes that I'm representing myself pro se, and before prosecution attempts to get to arraignment, there are dispositive issues that I intend to bring before the court.
Okay, and we can certainly set a time for you to do dispositive issues.
There are threshold matters regarding jurisdiction, and that needs to be addressed before the prosecution tries to proceed.
Okay, I understand. We can do all that. We just can't hear the dispositive motions right now on this count. But first, let me ask you a series of questions. All right. So, Mr. Benchu, you have the constitutional right to have a lawyer represent you, and you wish to waive that right at this point?
Well, I had a similar colloquy in Seattle Municipal Court. I'm not waiving my right to counsel. I still expressly reserve the right to retain private counsel, but I do not want a Northwest Defenders Association or whatever the organization is called representing me. And until I am afforded the right to speak with a private attorney of my choosing without being recorded, and having my right to privacy violated. Until that time, I intend to proceed pro se, Your Honor.
So there's a lot for me to sort of ask you about with that. You don't have the right to an attorney of your choosing if the government's providing you with a lawyer, which I think that's not what you're asking for. What you're saying is that you want to represent yourself until such a time that you may wish to hire a lawyer. Is that correct? Okay. But if I allow you to represent yourself today, I may not necessarily allow you to go hire a lawyer later on. It depends on a whole variety of things, one of which is how close we are to trial and whether or not it will disrupt the court process with it. Do you understand that if I grant your request to go pro se today, that you may not have the ability to hire your own lawyer later on? You certainly can ask me to do that, and I would take that really seriously, but that wouldn't be a right that you would have.
For the record, Your Honor, I understand that's the court's position and granted the respect that it's really that it's required to have. But at the same time, my right to counsel is not a discretionary privilege that's granted by a court. That's my position.
Okay, so you understand that I may take a different position with
Yes,
it,
ma'am.
but you disagree with that?
Yes, sir.
Okay. Have you ever studied law or represented yourself before?
I have represented myself. I have not gone to any formal education institution regarding law. I've done independent research on it.
Okay, and do you understand that the court has certain specific court rules and legal procedures?
I understand that there are criminal rules of procedure, civil rules of procedure, and there are different rules of procedure, whether it's a court of jurisdiction or a superior court or a federal court. Yes.
Okay, and do you understand that the court would be requiring you to follow those rules, even though you're not a lawyer?
Yes, I understand that Washington's position is that I'm held to the same standard as a licensed attorney.
Okay, and that a judge wouldn't be giving you an extra break just because you're not a lawyer yourself?
Yes, I understand that even though there are cases such as Ames v. Turner out of the United States Supreme Court that have stated that a pro se pleading should be held to a different standard than licensed attorneys, that the Washington courts have ignored that.
So currently you're charged with the crimes of felony stalking, attempting to elude a pursuing police vehicle, and then a third count of attempting to elude a pursuing police vehicle. Do you understand that's what you're currently charged with?
I understand that that's what the prosecution is claiming in violation of RCW 9.62.0 and malicious prosecution.
Okay. And Mr. Lavin, do you have standard ranges and the maximums for these crimes?
Yes, sir.
Are you able to state them for me on the record?
Yes.
Okay.
The maximum term for felony stalking.
Than any of my friends from it's almost like they're hiding me. Sorry.
Sorry.
That's okay. We will let you look that up, and I'm going to ask Mr. Benson some other questions here as well. So these are the three charges that you're currently charged with, but do you understand that the state may amend and add charges as well?
Yes, Your Honor.
Okay, and you understand that there could be, I'm not aware of whether or not there are any for these particular, but what we call lesser included offenses. So something that's less than, but still part of these offenses that you could be convicted of as well?
I understand that that King County could attempt to prosecute me maliciously, but because I'm actually innocent, it's an legal impossibility for there to be lesser charges. But I understand the court's position that it needs to inform me of this theoretical possibility.
Okay. Do you understand that it may be more difficult for you to interview witnesses while you are in custody?
I fully understand that. by firsthand experience because it's so far been so difficult that I haven't even been afforded a piece of paper or an envelope or a stamp to respond to either the Washington Supreme Court clerk or Robbie Subramanian, who is the clerk for U.S. District Court. And there seems to be a pattern or policy of violating my due process rights to hold me incommunicado. So do I realize it's a possibility that that may continue as part of the city and the county's retaliation campaign? Absolutely, Your Honor, and I'm prepared to deal with that each and every day with a smile upon my face.
Okay. Do you understand, similar to when we were talking about that you may at some point wish to try and hire your own attorney, that sometimes people believe they have a right to standby counsel, which means they still represent themselves, but they have a lawyer who's there standing by possibly to assist you. Do you understand that you don't have a right to standby counsel either?
I understand that that's the court's position, Your Honor.
Do you realize that if you decide to take the witness stand, a judge may require you to ask a question, then answer the question, then ask another question, rather than just stating in one long narrative?
I do, Your Honor.
Okay. Has anyone made any threats or any promises to you to have you represent yourself at this time?
No, the only threats I've received were from prosecutors, judges, and law enforcement.
Okay, and was that to make you represent yourself, or do you mean as part of why you're in custody?
The only reason I'm representing myself is because of the ongoing threats by police officers, prosecutors, and judges. But if you're asking me specifically about my representing myself pro se right now, no, there are no threats directly related to that.
Okay, thank you. I appreciate that clarification. One other thing that we talked a little bit about, we talked about court rules and criminal procedures. There's also the rules of evidence. So what's allowed in for a trial and what might not be allowed in for a trial. Do you understand that you have to abide by the rules of evidence, and are you familiar with them at all?
I am painfully familiar with the rules of evidence and how Seattle Municipal Court judges and prosecutors, including Katrina Outland, or no, sorry, Sarah, what's her name? Sarah, she's got it, Sarah McDonald. She's now a prosecutor with the King County Prosecuting Attorney's Office, and I'm familiar with the fact that judges and prosecutors violate the rules of evidence in order to violate my rights. I would hope that if a trial actually occurs here, that all parties will play by the rules.
All right, Mr. Levin, do we have the maximums and the standard range?
Yeah, so in count one, felony stalking, class B felony, maximum term is 10 years imprisonment and or a $20,000 fine. The other counts are attempting to elude pursuing police vehicle. Each of those are class C felonies, punishable by up to 5 years imprisonment and or a $10,000.
Your Honor, has the court completed the colloquy and has the court fully recognized my right to proceed pro se yet?
I'm this close, Mr. Benson. I just, the one final thing that I need is the standard range, just so you understand the possible jeopardy that you're putting in. So what Mr. Lavin just read was the maximum for each one of these crimes, but there also is a presumptive sentence depending on your criminal history and the seriousness.
And is the court's position that if those charges were valid and if I was actually convicted, that all of the charges could run consecutively?
So they presumptively run concurrently. So they would run together. The state can ask for what is called an exceptional sentence. So something, they have to find a legal basis to do something outside of the normal to run them consecutively. So it's a possible that there has to be a legal basis to do so, and the state would have to provide you notice of that and prove that, whatever the legal basis. Do we have a standard range?
Yeah, presuming that he was convicted of all counts, his standard range on the felony stalking would be 13 to 17 months. There are aggravated factors charged with respect to count one. So if those were found, there's some discretion to imprison up to the 10 years. And that would be the governing standard range, assuming what the court already articulated about current sentences. But with respect to the attempt to elude,
All right, and so Mr. Benson, did you hear what his possible standard ranges were for these crimes?
Yes, Your Honor.
And when I talked about an exceptional sentence, that is exactly what Mr. Lavin was bringing up, is that count one, the state is alleging two aggravating factors. One is committing the offense within the sight or sound of a minor child, and part of an ongoing pattern of psychological, physical, or sexual abuse of the same victim, and that the conduct manifested deliberate cruelty. Let me see. I don't. And the other one was an ongoing pattern of domestic violence. Both of those are what the state's alleging. Those could allow, if they're proven, that could allow the court to go above, so give something more all the way up to the maximum. Do you understand that?
I understand that that's what they're saying.
Okay, and it still is your wish to represent yourself?
Yes, I intend for truth to prevail in this matter, and the actual criminals, including the kidnapper of my son, Jessica Ray Owen, that's supposedly the star witness of the prosecution, her perjury and narcissism and her child abuse and kidnapping of my son will be exposed.
All right, so I am going to grant your request to go pro se after asking you all of these questions. Now, the next step is arraignment, but my understanding is that you want to have some motions prior to arraignment.
I have some objections to note for the record. My understanding is that the court does not have time at this juncture to hear any motions that I might make orally. You can correct me if I'm
That's correct. I guess
Okay.
what I was going to say is that we can either do the arraignment and you note your objections, or what we could do is continue that part of it and give you some time so that you can have your motions be heard prior to arraignment, if that's what you would rather do.
well.
And the court is still standing there, which I appreciate, but you're excused, Mr. Cook, at this point.
Good luck.
Just quickly, I ended up to order finding competency with Mr. Coulter. Mr. Coulter is concerned about Simon's getting.
Okay. Yeah, I understand.
Would the court provide me with a pencil or pen for the duration of the hearing?
So let me ask, I asked the jail about security issues, which that potentially is, but you're looking to take notes of what's going on?
Yes, I just want to scribble on my scrap paper, please.
Okay, I understand.
I'm an absolute pacifist.
So I'll take that from you, Your Honor.
You'll, okay, sure. Yep.
So it sounds like the court's giving me a binary choice. While I don't, while I would note my objection to any continuance and tolling of my right to speedy trial days, the most important thing is that the court recognizes that these dispositive issues should be heard before the prosecution attempts to arraign me. So if those are the only two choices and the court's noted my objections, then I would say let's set a motions hearing prior to arraigning.
You want to do, well, I guess we can do a couple different things. I'm not trying to make it either or. We can have arraignment, have you note your objections, preserve your objections, but at least start the speedy trial clock if that's what you want to do, and then have the motions heard at another time. Or we can just wait to hear the motions fully fleshed out at another time and then arraign some point after that. I'm not asking you to waive any of your rights if you're looking to sort of start things.
Thank you for that clarification, Your Honor. My preference would be to note objections for the record today and set a hearing at the earliest possible date for my dispositive motions to be heard. And if the court has not disposed of all of the charges at that hearing, then of course the prosecution is to be afforded the opportunity to attempt to proceed with arraignment.
Okay. All right, do you want to do the arraignment first, or do you want to note your objections for it? And then regardless, I'm going to make sure that you preserve your rights to it, and then we'll hear them sort of fully at some point later.
Oh, so maybe I misunderstood you. I thought what we discussed was the option where today I note my objections and we schedule for a later date at the court's earliest possible convenience, the hearing of my motions to dismiss, at which time the prosecution would also seek arraignment. Because my position is that we don't get to go to arraignment when my dispositive motions have yet to be heard, because the prosecution does not even have probable cause.
No, yeah, I understand what you're saying with that. What I'm trying to, it sounds like you want to start the speedy trial clock today,
If possible.
which it started with arraignment.
Then
And you
what-
want to preserve all your rights with that. And so I'm trying to do both of that for you, is for you to note your objections, do the arraignment, you preserve your rights for all of that, and then set it at a time that would start the speedy trial clock. And then we would set a time to be able to hear everything more fully.
Right, so I recognize the court's position on that. And I would just have an additional objection to note for the record, which is that I object to the fact that I'm still being incarcerated without probable cause, and that the speedy trial clock would toll until the motions hearing is set. But I'm going to stick to my position that arraignment cannot happen until after my motions to dismiss are heard.
Okay. So what I'm going to ask is for Mr. Lavin to do the arraignment. I'm going to allow you to preserve all that objection. And while that's happening, I'm going to ask my bailiff to set a time to be able to hear your dispositive motions completely. I've got that you are objecting based on probable cause. And is there another one that you wanted to note at this time?
There's several, Your Honor.
Okay.
So in no particular order, the prosecution is violating the fruits of the poisonous tree doctrine, because all of these alleged DV violations.
And I don't have time to sort of hear it all, but just fruits of the poisonous tree, that's enough. I understand what that means. So
Okay,
you're rejecting.
so it's clear for the record that that relates to King County Superior Court case number 21-5-00680-6, in which the prosecution star witness perjured herself in collateral and extrinsic fraud to fraudulently obtain a restraining order to conceal the kidnapping of my son perpetrated by Jessica Ray Owen, date of birth 11/23/1975, and Magali Elizabeth Furman, date of birth 1/31/1986. Secondly, we've got a violation of the priority of action doctrine, which the prosecution may wish to look at state the Stevens County District Court out of the Division 1 of the Washington Court of Appeals, I believe that's 2019, which states that once one court has, quote, when one court exercises its jurisdiction, the priority of action doctrine prohibits another court from interfering, unquote. What the problem that the prosecution has is that it's attempting to violate the double jeopardy clause of the Fifth Amendment of the United States Constitution, as well as Article 1, Section 9 of the Washington Constitution, by prosecuting me for the same alleged criminal law violations as City of Seattle was across its 10 cases. I would like to inform the court for the record that today one of my friends was able to file a petition for habeas corpus under 28 United States Code Section 2241 in the U.S. District Court for the Western District of Washington, case number 2:24-CV-01110-JLR-SKV, although for the record, SKV will be removed shortly because I filed a LCR 73 motion stating that I do not agree to having a magistrate judge preside over that case. And the court should further be aware of the fact that the lawsuit United States v. City of Seattle that was initiated in 2012 by then U.S. District Attorney Ann Davidson addressed the fact that the Seattle Police Department has a pattern and practice of not only biased policing but excessive use of force, is also being heard by Judge Robart, who will be hearing my habeas petition, and that I filed an amicus brief last year before Judge Robart, including one of my federal lawsuits, to inform Judge Robart, for the Robart cart, that it appears that the Department of Justice and the City Attorney's Office for the City of Seattle have been playing footsie and hiding from the Robart court that the practice of excessive use of force and biased policing
All right, so
is
Mr.
ongoing.
Benson, I'm really sorry to cut you off, but
That's
it's,
fine.
we just don't have the ability to do all of that. I will allow you to have the ability to be fully heard.
And
At this point, we really.
I have one more objection, Your Honor.
Okay, if we can keep it like this short, Mr. Benson, if we're taking too long at this point.
Okay. We've got a violation of Brady v. Maryland because the prosecution has been withholding the evidence from the search warrant from me that was used to arrest me by the SWAT raiding my house on July 3rd.
Okay. And
Within,
that's all I need to hear about, okay?
okay,
All
and
right, so-
then, and the exigency standard was not met.
Okay,
Okay,
I'm gonna have Mr. Lavin arraign you, and that will start the speedy trial clock, and then I'll let you know when we have a date set for you, unless you can be fully heard. Mr. Lavin.
Can I serve him with the information?
Yes.
Mr. Manager, I'm going to be talking the information on the, we're going to go through this.
thank you.
No,
Can I, Your Honor, can I get the spelling of the prosecutor's name from our records? Or is it on here?
I don't know if it's on here, but it's Ladin is his last name, Mr. Lavin.
Okay,
sir, is your true and correct name Kurt Alden Benchuk?
yes,
Sir, Lisa Manning, prosecuting attorney for King County in the name by the authority of the state of Washington to accuse Kurt Alden Benchuk of the following crimes, which are of the same similar character and which are based on the same conduct or a series of acts connected together or constituting parts of a common scheme or plan. Felony stalking, attempting to elude pursuing police vehicle, attempting to elude a pursuing police vehicle committed as follows. Count 1, felony stalking. That the defendant Kurt Alden Benchuk of King County, Washington, at the time intervening from March 14, 2023, July 3rd, 2024, with lawful authority. 1A, did intentionally and repeatedly harass Jessica Ray Owen. B, did intentionally and repeatedly follow Jessica Ray Owen. And C, did intentionally contact, follow, track, monitor, or attempt to contact, follow, track, monitor Jessica Ray Owen after being given actual notice that Jessica Ray Owen did not want to be contacted, followed, tracked, or monitored. And D, did knowingly and without consent install or monitor an electronic tracking device or cause an electronic tracking device installed, placed, or used to track the location of Jessica Ray Owen. And Jessica Ray Owen 2A suffered substantial emotional distress, or 2B was placed in fear that the defendant intended to injure her or another person or property of Jessica Ray Owen or property of another person. And that substantial emotional distress and or fear was one that a reasonable person in the same situation would experience given the totality of the circumstances, or 2C, where the defendant knowingly and without consent installed a monitor electronic tracking device or cause an electronic tracking device to be installed, placed, or used to track the location of the victim. The victim's knowledge of the tracking device would reasonably elicit substantial emotional distress. Here, 3A, the stalking violated any protective order protecting Jessica Ray Owen. Contrary to RCW 9A.46.110, Section 1, 5B, and against peace and dignity of the state of Washington. Further to allege the crime involves the following aggravating factor and accuses the defendant Kurt Alden Benchuk committing and said offense involving stalking as defined in RCW 9A.46.110. 1, within sight or sound of the victims or the offender's minor child under the age of 18 years. And 2, that the offense was part of an ongoing pattern of psychological, physical, or sexual abuse of the same victim or multiple victims manifested by multiple incidents over a prolonged period of time. 3, that the defendant's conduct during the commission of said offense manifested deliberate cruelty or intimidation of the victim. This allegation is under the authority of RCW 9.94A.535 3H. And further to allege the crime involves the following aggravating factor and accused the defendant Kurt Alden Benchuk committing said offense involving domestic violence as defined in RCW 10.99.020, and the offense was part of an ongoing pattern of psychological, physical, or sexual abuse of the same victim or multiple victims manifested by multiple incidents over a prolonged period of time. This allegation is under the authority of RCW 9.94A.535 3HI, and further to accuse the defendant Kurt Alden Benchuk at said time of committing the crime against an intimate partner as defined in RCW 10.99.020, which is a crime of domestic violence as defined in RCW 10.99.020. Count 2, attempting to elude a pursuing police vehicle. That the defendant Kurt Alden Benchuk in King County, Washington, on or about April 27, 2023, while driving a motor vehicle and having been given a visual and audible signaled by uniformed police officer to bring the vehicle to stop, willfully failed, refused to immediately stop, drove the vehicle in a reckless manner while attempting to elude a pursuing police vehicle that was equipped with lights and sirens, contrary to RCW 46.61.024, against the peace and dignity of the state of Washington. Count 3, attempting to elude a pursuing police vehicle. The defendant, Kurt Alden Benchuk, in King County, Washington, on or about August 23rd, 2023, while driving a motor vehicle and having been given a visual and audible signal by a uniformed police officer to bring the vehicle to a stop, willfully failed and refused to immediately stop and drove the vehicle in a reckless manner while attempting to elude a pursuing police vehicle that was equipped with lights and sirens, contrary to RCW 46.61.024 and against the peace and dignity of the state of Washington. I ask you to enter a plea with this.
You want to enter a plea at this time?
I'm actually innocent.
And so I will enter a plea of not guilty on your behalf. All right, Mr. Benson, I think we do have a time of August 15th. So in about a week's time at 3 o'clock for your motions to dismiss to be heard more fully.
Okay, and there's an issue that I ran into yesterday, which has hopefully been rectified, which is that the DAJD has not been providing me any computer access, no printer access, anything. So if the court would please issue an order clearly stating to the DAJD that I am pro se litigant and that I should be afforded all of my pro se materials, computer access and printer access, so that they can't any longer say that I don't have the right to do that.
Sure. So we are going to do an order that says you're pro se, and we can get you a copy of that order so you have that information. As far as directing DAJD to allow you to have computer access and printer access, I can't really do that without their lawyer present as well. I can't pretend that I remember exactly what the booklet for DAJD says about your rights now that you're representing yourself, but my understanding is you will have some rights to be able to use those, but I wouldn't do an order or entertain a motion on that just yet without their lawyer being able to request. And when
Understood. And
okay, yeah, so we'll make sure that that order that says that you're representing yourself now will get sent over to the jail. And so they will know that for all the different things to be able.
okay, and I would like to move for the release of myself on my own personal recognizance.
Okay,
for
and
the
we've
jury.
got to set that for a motion too. All right, but we'll make sure that we set that. Do you want to do it at the same time?
That's fine.
Yes, so we'll set it at the same time as the motions to dismiss on the 15th.
Okay, and last question is, I have not been provided from the prosecution the complete search warrant documents for SW 24-0-62121-3. I would like, if the prosecution has those today, I would like copies of them, as well as I need copies of the search warrant that was allegedly obtained by SPD detectives for my cell phone ping data, which is mentioned by SPD Detective Ryan G. Ellis on page 9, paragraph 3 of Ellis's certification of probable cause, which was included with the county's information filed on July 8th, 2024.
So Mr. Benson, you are going to be entitled to all the discovery in this case, including any search warrants that are directly related to this case. I don't know whether or not those numbers of the search warrant are directly related to this case.
Fair.
But if you want to bring the motion on the 15th to include a motion to compel, which would be to compel this type of discovery, then you can do that as well. But the state does have discovery obligations to provide you with all of the materials that are relevant. And if you think you're missing something, you got to give them a little bit of time to get it to you, right?
Well,
But if you think you're missing something, then you can ask the court to compel them to do that.
yeah, so as part of that motions hearing, I'd also like to include an evidentiary hearing pursuant to Franks v. Delaware, Supreme Court 1978, to challenge the validity of the search warrant.
Okay, well, what we can hear is next Thursday is whether or not you're entitled to a Franks hearing. You don't automatically get a Franks hearing with it. We can talk about that.
Okay.
We won't have the ability to do a full evidentiary hearing next week, but we can talk about whether or not that's something that's appropriate to order or not. All right.
Thank you.
So it's a pretty ambitious schedule for
It is.
your hearing. So it may be that we're not able to do all of it then. So think about in your head what you want to prioritize and make sure that if you have any written materials for your motion, that you get it to the prosecutor in advance.
I
as
will
well as
if
to the court.
I'm afforded that possibility.
Okay, Understand.
If I'm not, then I would, of course, claim that once again that my due process rights have been violated. Thank you, Your Honor.
We're gonna be done for today, but we'll see you next week.
Wait, sorry, Your Honor. The state's gonna ask court set conditions of release.
I'm sorry. Yeah. Okay,
And we have to set the new dates for those.
okay. So what are the conditions of release?
Yeah, the state's asking the court maintain the previously ordered bail $500,000 and have no contact directly or indirectly in person, writing or by phone, personally or through another person with Jessica Owen, Miss Owen's children, Magali Lerman, and that he have no new law violations, keep his address updated with the court, appear at all future court hearings pursuant to criminal rule 3.4, strike, maintain contact with counsel.
And Mr. Benson, I just want to say, I was wrong about your ability to ask for release today. I was, given that we've seen you a couple times, because we are just doing the arraignment and the state needs to set conditions of release, you do have the ability to ask for release now. And Mr. Lavin, I'm sorry if I cut you off. There was something more that you were asking for your conditions.
Just the RCW 1099 order prohibiting Mr. Benchu from having any contact with Jessica Maitland. I do have a statement from her. However you want to cut.
Why don't we hear the statement from her first, and then Mr. Bensu, if I'll hear your request to be released.
Your Honor, I would object to the reading of a statement by Jessica Ray Owen, who's a pathological liar, who I've already evidenced in numerous court cases committed perjury without me being afforded the opportunity to question her here.
This, just for a bond hearing, we're allowed to hear hearsay for it, and alleged victims do have the right to be able to be heard either directly or in this fashion. So I'm going to overrule that objection and let Mr. Lavin continue.
If Kurt is given the opportunity to be released, I worry that he will only escalate further. He has engaged in patterns of violence that put me in and simply share in danger. Kurt has no regard for you, the police, or the court. He has stalked me, harassed me, and used our son to gain access to my life. I ask that you please keep his bail at the amount you have it currently set forward, and that you issue an NCO as a safeguard. Your Honor, I am terrified of Kurt and what he might do next. If you release him, I will have to take my minor son, disrupt his life and mind, and go into hiding out of fear that Kurt will cause us further harm. Your Honor, if you must lower his bail, if you chose to release him, I ask you please release him on EHD with victim notification. And I'm going to hand out an appendix B. I want to show Mr. Benchu before I hand it.
And can you provide copies? I think I already have a copy of that, but if you could provide me a copy of the documents that you're reading today, that would be great. I have objections to all of those conditions, Your Honor. And the reason being that they're patently absurd and obviously false. Miss Owen wasn't even concerned enough to block my cell phone number. She's been more than happy to receive text messages from me because, as my text messages actually show to her, her intent is to try to get me unlawfully imprisoned. She's not afraid of me. There's been no allegation that I've ever so much as raised a hand at her, because we've already been through King County Superior Court. The only times that Miss Owen and I were afforded the opportunity to testify in court was before Commissioner Schaefer on 9/3/2021. And Commissioner Schaefer, if you look up that, there was a full dismissal order issued by Commissioner Schaefer. Commissioner Schaefer said that, quote, I find Mr. Benchu's testimony to be credible, unquote, which in other words means Commissioner Schaefer found Jessica Ray Owen's testimony to be false. She has a pattern of maliciously lying. She's not actually afraid of me. The only thing she's afraid of is that her crimes are going to be exposed. There are already allegedly valid restraining orders issued by Judge David Keenan, by Judge Willie Gregory, and this is an absurdity and a waste of court resources. Even if I was Ted Bundy, having a third set of restraining orders saying basically the same thing is absurd. As far as the bail goes, I'm financially indigent. There's already $360,000 of warrants out of Seattle Municipal Court that are a violation of the 8th Amendment. And I mean, I've been in jail. I've met people accused of murder, of bank robbery, and a host of other violent crimes. And my current bail amount is higher than theirs. So I understand that that's the county's position. They're trying to paint me as the perpetrator, but my son and I are the victims. I've tried to address all of these issues in multiple court cases, and instead of being fairly heard, I've been accused of being vexatious when I'm simply trying to stop the kidnapping and abuse of my son perpetrated by 2 perjuring prostitutes. That's what Jessica Ray Owen and Magali Elizabeth Lerman are. They've made careers on deceiving men and people with money and people in positions of power, and that's all they're continuing to do. So that's my position, Your Honor.
Let me take a look at the certification here, please. All right, so Mr. Bensu, I just want to say that your argument basically rests on facts of the underlying allegations. I understand that that's really important. That's just really difficult for me to make a determination prior to a trial. I have allegations that you committed a series of violating court orders. I understand that you are saying that that's untrue, that the person who's making those allegations is doing it to harass you, and that that person has been found to be not credible in prior court hearings. That's all important stuff for a trial. It's really difficult for me to make a determination as what's accurate, this or you, under these circumstances. So what I take a look at is then your ties to the community, your risk to fail to appear in court, your risk to violate court orders, your risk to interfere with the administration of justice, and your risk to the community or the individual who's making these accusations in this case as well. And hold on, Mr. Bensu, it's my turn at this point to talk. I am making those findings at this point, and then I go to what the appropriate bail amount would be. Right now, the bail is $500,000. I am going to reduce bail, given your very limited criminal history, to $250,000. I'm going to further make the requirement that if you were to post bail, you would also be placed on EHD with GPS and with victim notification. I am going to order all the other conditions as well, which is to keep the court updated with any address, to come to court as needed, to not commit any further court violations. If you were arrested on a new charge, that would be a violation of this as well. You wanted to say something further, Mr. Bensu?
Yes, Your Honor, thank you. I just would like to note my objection for the record that Detective Ryan Ellis is a co-conspirator, that he was the one that supposedly served me with the final restraining order from the family court case, which he supposedly filed record of into case number 21-5-00680-6 on or around November 15th of 2022. And I've already showed in court, in federal court, that not only did Detective Ellis not serve me, so that means even if this restraining order was valid, I wasn't served with it, but that Mr. Ellis knew full well that I had no guns in my house because he is personally.
Right, Mr. Benson, this is all too much. And then the one final thing was
That's
the no contact order. I understand that you're saying there's already no contact order, so it's duplicative. I only have control over the order in connection with this case, and so I am going to order a no contact and the 1099 order in connection with this case. We need to set next dates. Can you please do that as well?
The state calculates expiration that has speed trial commencing today as October 7th, 2024. We ask for a trial date of September 24th and omnibus date August 20th.
Okay, so we'll set the omnibus date of August 20th, and that's essentially a trial readiness. And I'm sorry, the trial date of September 24th?
Yes, please.
Okay, the trial date of September 24th. All right, so Mr. Benson, we do have a copy of the no contact order. Typically, we ask defendants to sign it. I don't know if you're willing to sign it or not, but we will get you a copy of the no contact order so you have all that information, okay?
Thank you. And for the record, I'm not willing to sign it, but for the record, you handed it to me.
Okay, understood. But I will ask though to make sure that you read through it so you understand specifically what I'm prohibiting you to do, which
I
is
will, Your Honor.
no calls, no emails, no third-party contacts. Okay.
And you want Mr. Benchuk to have a copy of the order signed by yourself.
Okay, we'll do that then.
I'm sorry, I do have another copy, just always his matter signature on it.
Sure, okay.
All right. These are the orders setting the dates, so that's where this, those dates we just talked.
Okay, right. I got it.
Okay.
Okay, copies, right?
Okay. This is an omnibus application, which makes our written advance for discovery. Yeah. Okay. Requirements. And that's. So, two copies, mentioned your signature block that wrote refused to sign. Okay.
Yeah, it's fine. They won't be an issue. But thank you.
Okay, and then second. This is the order that sets conditions of release, okay, which indicates that Margaret argued for less restrictive conditions of release. The court said bail in the amount of $250,000, electronic home detention with GPS monitoring, and victim notification if bonds posted, and then have no contact with Jessica Owens, Someone's children's, Magdalene Lerman, Magalia, and then the other conditions that I read on. Yeah, yeah. Okay.
Do we have PhD conditions? There's some in business here. Mr. Levin, they're over in front of the podium.
Yeah, Mr. Levin, I know that you don't typically do the EHD conditions, but I just want to be sure that we have everything for Mr. Bencher.
And you have a copy of it. So that's just an application. So I'm gonna give you the. You have an order to participate in electronic conversation. The other stuff I got to fill out. Yeah.
And do we also have a waiver of counsel allowing per se been executed?
Not yet, I'm gonna.
Right, Mr. Benson, this is your conditions of release. Did you want to sign this or do you want to refuse to sign this as well?
I would like to decline to sign.
Okay.
Refuse just sounds too stubborn.
Is it all right with you if I write decline to sign them?
Just sign it.
This is the copy that I'll contact. So I served Mr. Bench his copy of the RCW 1099 order prohibiting him having any contact. These are the conditions conduct for people who are on electronic home detention. These are things you gotta fill out. So if you want to go on the HQ. Okay, thank you. I can't go over that.
Right, so Mr. Benson, with those, what I'm going to tell you is that if you don't sign those, you won't get released to EHD if you're able to make bail. So what I did is I reduced your bail, but then added the condition of electronic home detention. What I am going to do though is we need to go on to the other matters we have on today. If you do wish to sign that, then you can give it to us a little bit later, but I want to give you the chance to read through it all rather than just telling you to sign, unless you want to just sign, but I don't want to push you to do that. You just won't go to EHD and won't get released.
That's fine, yeah, I'll hold off on signing it, which will afford me time to read through it fully, and then you can get on to other matters for today.
Okay, we'll do that. Then we're gonna go ahead and, unless Mr. Lavin, is there anything further on Mr. Benson?
I haven't produced the waiver of counsel form yet. So I'm working on the record.
Okay, well, why don't we go ahead and let Mr. Benson go back so we can handle other things and we can go to that.
But he needs to stay here.
Yeah, he'll be here.
Yes, okay.
All right, thank you.